Hello to all of you from around the world. I want to thank you for joining us for this edition of Soulivity Today. We're broadcasting live from our studio right here in the nation's capital, Washington, D.C., and on KMET 1490 AM radio in Southern California. My name is Brian Westley Johnson, and whether you're at home, driving, or even at work, we are always glad you're here with us. Now, I'm so excited about today's show, because with me today is our special guest, ASHA RANGAPPA, who is the Assistant Dean and Senior Lecturer at Yale University's Jackson School of Global Affairs. Hey, girl, what is happening with you?
Too much to keep up with.
My mind is kind of blown because of everything that's happening in the world right now. I mean, I don't know of a time in recent modern history where we've had the stuff that's happening here in America, but also around the world. I mean, between Ukraine and things that are happening on the Gaza Strip, to other areas of the world where we're not even really talking about. So thank you for being here. Always been a fan of yours and your commentary. We're going to be talking about your Substack a little bit later on, the Freedom Academy, which I love. But ASHA is here to help us talk about the latest and greatest legal news across the United States. You know, it's important for us to make sure that we empower you with fact-based information so you can be totally informed when you may need to make decisions about your elected officials or political issues or global events. So thank you again, ASHA, for being here. I think why don't we go ahead and get started here. When I saw this first story from Reuters, my first reaction to it was, remember Gomer Powell back in the day? Surprise, surprise, surprise. Former President Donald Trump posted a $91.6 million bond to cover the defamation verdict in favor of writer E. Jean Carroll, and began his appeal of a case that arose from his branding her a liar after she accused him of raping her decades ago. Now, the bond from Federal Insurance Company, part of the insurer Chubb, would cover Carroll's $83.3 million judgment if Trump were to lose his appeal of the January 26 verdict and refuse to pay. So, Asha, again, I was shocked that he actually was able to get this money. I don't know how he got the money. We can talk about that in a second. But my first question to you is, when you first heard about this story, what were your first thoughts?
My first thoughts were, like you, I was surprised that he was able to secure this bond. So for the listeners, the reason that he has to post this bond is that in order to appeal, to prevent defendants from trying to delay paying out and just appealing, so that they can, spend all their money and avoid, being held accountable. What New York courts require is that you put the money up front that you owe, along with interest, which is why the total amount is greater than the actual verdict that she was given. And then you are allowed to appeal. And if you, lose the appeal, the prevailing party will get that money immediately. And if you lose, then you get it back. Now, the way this normally works is that there are essentially surety companies, like insurance companies, that will post this money for you. And so what Trump would have to do is provide that company with collateral and then also pay a premium. Right. So he's paying probably like 10% of the verdict as a premium that he's not going to ever see back in order for them to post this bond. So what I thought when I first saw this is, I was really surprised that he was able to get a company, an insurance company to underwrite this essentially.
Yeah.
Because remember in a separate case, which we probably will talk about, maybe not, he's been accused of defrauding insurance companies.
Right.
Misvaluing his assets. So anyway, so that was the first thing. The second thing is that I believe E. Jean Carroll has until this morning to object to him posting that bond and
Oh.
appealing. This is a win-win really for her
Mm.
because, you know, if if he posts it and then he loses, as I mentioned before, and I think it's likely that he's going to lose. I don't know
Right.
what his legal basis is for appealing. She gets the money immediately. She doesn't have to go through enforcement proceedings. And in other words, if
What?
he loses, what the insurance company takes on as their risk is that they will have to be the ones to get all the cash out of whatever collateral Trump
I
has put
did
on. So
not
this is
know
actually a
that.
really, yeah. So this, as far as I know, she was celebrating on her Substack when this happened because, you know, this is for her. If you think that you're going to win, ultimately, it's actually a much faster and more efficient way for her to recover the judgment.
Hmm.
Um, I'm not sure if Trump realizes that, but anyway, that's what I thought. I was
Well,
like, well, this seems like good news for her because it would have been a protracted battle for
yeah.
her to try to go after him and enforce that judgment. I mean, not that she couldn't have, but she would have to like, I don't know, sue
Seize
him
like seize
in some ways. Yeah,
property and then go through all
exactly.
that kind of stuff. Oh man. Yeah. Well, I didn't know that she would just get the money immediately
Yeah.
around that. I have to, you brought up a good point earlier today. I mean, we're not going to be talking about, I mean, there's so much news to talk about around the former president. I try to keep it balanced, but um, about the financial case. And I was wondering when this all happened, I'm like, where did he get the money? Is if the properties are that he's using as collateral, maybe for this, are in are being monitored by the monitor in that case, how does the monitor okay him using it and all that? I mean, it's a big hairy mess. And so I was really shocked. I was like, okay, wait a minute now. You know, there's a lot of hoops he would have had to jump over if he was using his own assets as the means to secure the bond. So I can't I have to ask you really quickly. I'm going to your national security side of your expertise now. So you got to put that hat on. Um Orban was there this week, and then at Mar-a-Lago, at his home in Mar-a-Lago. And then earlier in the week, it was apparently, I think Elon Musk was there at his home. And it was like, why are they coming down to Mar-a-Lago? And then that almost the next day, this bond got posted. And I'm thinking, okay, from a national security perspective, does the public have a right to know, as he's running for presidency, right? The second time, but actually the third time, do the public have a right to know how he secured that bond from your perspective?
I think they deserve to know. I don't know if there's any mechanism. And, that's an interesting point that I hadn't thought about, that we don't know who put up what collateral in order to
Mm-hmm.
secure this, right? Like, where I
Mm-hmm.
was assuming that somehow Trump had managed to put up whatever property, or et cetera. Though, as you note, that's also not, from an insurance company's point of view, maybe not always the best investment because his properties are highly leveraged. So they would
Right.
be in line behind who knows how many creditors. So you're right that it's possible that there was someone else that was, putting up some kind of collateral or guarantee to the insurance company to post the bond. And I think, to your point, the reason that this becomes incredibly important for voters is Trump then owes these people.
Right.
If he loses,
Right.
those
Right.
people are about to lose their money.
Right.
Those
Right.
people are about to lose their money. Okay. And that money is going to go to E. Jean Carroll. And then Trump
Mm-hmm.
owes those people. And so then if he ends up in the Oval Office, the question is, who is he beholden to? Whose interests? Not
Right.
only, could it be Elon Musk? It could be a foreign government, you know?
Mm-hmm.
Um,
Mm-hmm.
and I think that that is incredibly problematic. As
Mm-hmm.
you noted, in Trump's civil fraud trial, which is a completely separate trial than the defamation
Mm-hmm.
trial, for which
Right. Whew.
he owes close to what, $500 million,
Yeah.
and that's a whole separate
With
thing that he has to
interest.
find. Yeah, and that's another one that he would have to post a bond for to appeal. As you noted, the court in that case appointed basically a babysitter
Mm-hmm.
for the Trump organization. So that babysitter is a judge named Barbara Jones, and she has to approve all of the transactions now that take place with the Trump organization because they can't be trusted to, do it on the up and up. So
Mm-hmm.
she has to actually approve this bond. But again, I just honestly, I don't know the details of how much she can see beyond the company. You know what I mean? If the company is
Mm-hmm.
saying,
Right.
hey, we're guaranteeing
Right.
this money, I don't know if she can even say, hey, I need to know who's securing the collateral.
Mm-hmm.
So,
Mm-hmm.
that's a great point and a great question that he's used now this intermediary company that could potentially shield the actual source of uh, the the money or collateral that's being provided.
Right. Right. And I just want to remind our viewers, I mean, these are just factual information that's out in the public sphere, and that came out of the former president's mouth, where maybe a couple of months ago he was bragging about how much cash he had on hand. Right, he had something like $400 million or something like that he said. This was before the financial case ruling on the damages in terms of the award. And so if he's having all this trouble, why wasn't he able to just get in a bond immediately? Right. um there was there was a deal where he tried to put up, like, say, well, I'll give you $100 million for the financial case, and then that got smattered down. Right. And so did he use that for the EJ and Carroll case? We don't know. But these are all important things that everyone needs to know, I believe, as we're going into the presidential election, now that we have a definite Republican and Democratic candidate. And if these people who have given Donald Trump money, if that has happened, we need to know about it. That's a heck of a lot of money. I mean, this is a heck of a lot, so, is he going to put his interest in front of our interests if he becomes the next president? And if history is prologue, then we already know the answer to that. So I should thank you for that.
You're welcome.
And that's all I'm going to say about that one. Listen, everybody, we're going to take a quick break, but we've got more legal news with ASHA coming up, where we're going to be talking about this unanimous decision, or was it yet unanimous, about the insurrection and our election. So we'll be right back in about 2 minutes.
Do you see me kneeling on this dual roller called Parasetter? It's actually comfortable because of this channel and the softness of the special foam. It feels like my kneecaps are being massaged. When I lie down, my spine is housed in this channel, while the convex rollers massage my muscles. They let go and lengthen. There's a traction effect from my head on the headrest and my mid-back from the rib wrap, which hugs me. When I start the breathing sequence, I feel calm because my cortisol levels are dropping. Lower cortisol means bye-bye constant hunger. Parasetter is 40 inches long and much more comfortable than old-style rollers, but it weighs only 10 ounces. Parasetter, just like Pilates was, is no longer an insider secret. Do yourself a favor. Reset your parasympathetic nervous system. Defeat stress. Lying, sitting, kneeling, or standing. This unique patented roller helps everyone.
Hi there, Sheila Applegate here with some exciting news. I've joined the incredible Soulivity team as the host of the new Consciously Awesome live show, where I will be sharing insights to help you discover your full brilliance and claim the vibrant life you deserve. So tune in every Wednesday right here on Soulivity TV to join the fun, and remember to subscribe to the channel so that you don't miss a single episode. Have an awesome week, and I will see you on Wednesday.
Hey, we're back here on Soulivity Today, where we're talking about some of the latest legal news across the country with legal expert ASHA RANGAPPA, Assistant Dean and Senior Lecturer at Yale University's Jackson School of Global Affairs. I just love the name, that name. It's like the Jackson 5, like Jackson's School of Global Affairs. I know I'm nuts. ASHA, last Tuesday, the U.S. Supreme Court acted unanimously when it sided with Donald Trump and prevented states from barring candidates for federal office from ballots based on a constitutional provision concerning the insurrection or insurrection in general. I think everyone in the legal world kind of figured that this wasn't going to fly with the Supreme Court, just broadly speaking. And that they were going to do it 9-0. But from your perspective, what do you believe we should know about this decision? And what are its ramifications for future elections and potential legislation from Congress, which is something I've been hearing people kind of talk about?
Yeah. So I would say that this is more like a 5-4 decision. Because although there was unanimity in that bottom line outcome, right? Colorado can't kick Trump off the ballot, and states can't kick Trump off the ballot. That's what they all agreed on.
Right.
And they all agreed that the rationale here was that there were a couple of bases. One was kind of looking at the 14th Amendment, and they said, listen, like, this was intended to curb state power and give the federal government more power to, you know, make sure that states couldn't go rogue, you know, when it came to like civil rights and things like that. So to interpret this as allowing states to have this much influence over a federal election would make no sense. And also, practically speaking, you would end up with all kinds of patchworks of, you know, people appearing on some ballots and not others, and being kicked off through different processes, et cetera. So they agreed that states could not enforce Section 3 of the 14th Amendment for people running for federal office. Now, they did not say that for state office. So these, you know, January 6th folks who are just trying to run in their states could still be disqualified. Where the departure happened, and then you see a lot of, like, you see some, you know, bickering, I guess, among the different concurrences, is that the 5 justices who write in the majority, and it's a per curiam opinion, which means that we don't know, you know, there's no single author of it. They're all writing as one. They go a step further and say that enforcement belongs to Congress. And they suggest that Congress would need to pass some kind of enabling legislation. What I understood it to mean is that I guess they would provide some legislation outlining a process where you can adjudicate someone to be an insurrectionist or not. You know, they say, for example, the only thing that really exists right now is the criminal statute for insurrection and rebellion. So presumably, if you were charged with that crime and you were convicted, then that would be sufficient to disqualify you under Section 3 of the 14th Amendment. Trump has not been charged with that crime. But by suggesting that this would have to happen through legislation, they really narrowed the scope of what would need to happen even in Congress. So, for example, if you look back at impeachment, Trump was impeached for inciting insurrection.
Right.
And more than half of the Senate voted to convict him. I mean, a majority of Congress actually determined that he was an insurrectionist. If you want to just kind of look at, you know, what did Congress decide? Then you also had the January 6th committee, which made a factual finding that he had engaged in insurrection. Those do not count under the way that the Supreme Court has determined it. And so basically you're in this position where insurrectionists can get elected to Congress, and then they're put in charge of whether or not to create enabling legislation that would disqualify them from being in Congress. So it sort of doesn't make sense. And so you see the 3 liberal justices saying, this don't make no kind of sense. And Amy Coney Barrett is also like, it kind of doesn't make sense, but everybody else gets all get along, you know? But it's all, there's nothing in there that says concurring in part, dissenting in part. You know, I think there was an effort to make this look like we're all in agreement because of how politically charged this is, but there is significant disagreement happening in this opinion.
Did you catch Judge Ludick's response, or I think pre-response to this on, I think it was either on CNN or MSNBC, where basically he took the opposite perspective, which is the Supreme Court didn't even have to they didn't have to go this far, number one, and he said they didn't even have to rule at all, and that if a court in the state basically determined that because of the information that they had that he's off the ballot, that the Supreme Court could have just let that stand. And it said, yes, it would have been messy. The states would have been going through different things, but that's better than what they did, which is basically you can have insurrectionists that have been voted into office in the federal space, which is completely against the complete, not just spirit, but the actual writing in the Constitution around insurrection that came after the Civil War. What do you think about that?
I think that that's how we operate in a lot of other types of qualification questions. I mean, as the lawyers for Colorado argued to the Supreme Court when this was up for oral arguments, there are candidates who appear on the ballots in some states and not in others, including for federal office. It's just that we never notice because they're randos. And it's not, do you know what I mean? It's never like a major party candidate. I think that was what the Supreme Court couldn't deal with. And that's, that is not anything that has to do with what's written in the Constitution, which is, I think, Judge Ludick's point. That's a policy question. I don't know how you address that. But, when I think back, for example, to the 2016 election, if I recall, Evan McMullin was an independent candidate who appeared for president on the ballot of several states, but not all of them. He was not on all 50 ballots. And, we didn't have a big Supreme Court case about it. It happens. I think they did not want to go there. And frankly, I think to take Judge Ludick's point even further, the way that the court could have avoided even that and kept the uniformity is just to put on their big boy and big girl pants and just make the call on whether Trump engaged in insurrection.
Absolutely.
You know what? I know that people would be mad either way, but That's your job. That's why you get lifetime tenure. That's why it's your job to look at the words of the Constitution and then the facts
Absolutely.
before you and say, and just say, he engaged in insurrection. He did not engage in insurrection. Done.
Right.
Then you don't have to get into all this nonsense about who's got, Congress and states and blah, blah, blah.
Right.
You're just making the factual determination.
And if this is my thoughts about it, just the thoughts and feelings expressed by Brian Wesley Johnson are his own. I think the reason why they did this is because I think that they already knew based upon the evidence. I mean, you had courts already take this to heart. The Supreme Court in Colorado really went down deep into this and looked at the evidence. And I cannot see the Supreme Court saying their evidence was flawed and their judgment was flawed, because they didn't say that. There was no mention of that at all in their ruling, right? So I think they already knew the answer to the question. And the question is, yes, Donald Trump engaged in insurrection, and that he would have had to been taken off the ballot. That would mean in the conservative sphere of America, that would have been a bomb. It would just been a huge bomb that would have gone off. And now you're dealing with a situation where my guess is states that are led by Democrats, they would take Trump off the ballot. And now there's a big mucky muck. However, we can't have an insurrectionist be president of the United States. That's the spirit of what's in our Constitution, right? Yeah. Anyway.
Yeah,
that's my
and
thoughts.
I mean, you make an incredibly important point that he has been determined by a court, by the Supreme
Correct.
Court of Colorado, to have engaged in insurrection.
Right.
That factual determination still stands. Nobody has contested it, and that part has not been overturned. They didn't, as you noted,
Nope.
They didn't say it was wrong.
Nope.
The Maine Secretary of State, through an administrative hearing, also concluded that, as a matter of fact, Trump engaged in insurrection.
Mm-hmm.
So these factual determinations are out there. And Brian, this is why they had to do that legislation, caveat, because he is definitionally, constitutionally disqualified from holding the office of the presidency.
Absolutely.
And what they didn't want to happen is, if he wins and let's say Democrats control Congress, I think they understood that then you would end up with a mess as well. Like, let's say they pass some kind of joint resolution that he's they needed to create this high bar, because obviously by making it legislation, then, that legislation would then go in front of Trump's desk for
right
to be signed into law.
Right. And again, I think the bottom line is, and then we'll move on to our next story, is something that you just said earlier, which is it is the Supreme Court's job to make a determination based upon the case in front of them, which was at the heart of it, is Donald Trump an insurrectionist or not? That's
100%.
That
was the
question
issue.
That was the issue, right? And then based upon that answer to that question, maybe you move into whether the states have the power or whatever. But come on. Anyway, why don't we move on to our next wonderful story?
Okay.
This is another Supreme Court ruling. I mean, they came out gangbusters. I mean, things that are happening in the Supreme Court, not a ruling, but a scheduling. ASHA, the U.S. Supreme Court has set April 25th as the date it will hear Donald Trump's claim of presidential immunity from prosecution on charges related to his efforts to overturn his 2020 election loss, the last day of oral arguments of its current term. Again, these are so bizarre. I mean, they're just as bizarre as the case that we just talked about, because they have so many different ramifications and outcomes and this kind of harkens back to the 2016 election, where a week or two before the actual election day, FBI Director James Comey reopens the case into Hillary Clinton, and people were complaining because of, this is going to affect the outcomes and da 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 da. And I look at this as the same, because this will affect the timing of the actual January 6th case that's done by special counsel, correct?
Yes. So just so everybody knows which case we're talking about now.
Right.
This is Trump's claim that he has absolute immunity from criminal prosecution for any, quote, official acts that he took while he was in office.
Mhm.
This is basically what his lawyer argued, was that the president could order SEAL Team 6 to assassinate his political opponent. And once he left office, unless he left office after being impeached and convicted by the Senate, he could not be prosecuted for that act. So it's crazy town.
Yeah.
And the Court
Yeah.
of Appeals wrote an excellent opinion, which really, I think treated with these arguments with more respect than they deserve, to be honest.
Right.
But and then knocked them down one by one. He had a lot of different rationales for why this would be true. Court of Appeals said no. I think the Supreme Court had the opportunity to just not take this case and be like,
Hello.
yeah, that makes sense to me. I don't think it makes
And
sense for.
And that's basically them. They could have, quote unquote, ruled on the merits of the appeals court and said, we're not taking this up. We agree with the appeals court. Y'all go handle that.
Well, in not taking it, the appeals court decision would have stood. I mean, I think the question is that what they're going to do now? Have they delayed this just to say, oh yeah, we agree, we just want to be the ones to say it? If they believe that this is such an important question that only the Supreme Court can have the final say, then why didn't they take it in December when the special counsel asked them to expedite and skip the Court of Appeals entirely, and they just sat on their butts basically and didn't take it. So now they waited till the Court of Appeals has issued this very thorough opinion. Then they're like, okay, we're going to take it. We're going to hear oral argument in April. Meanwhile, back at the ranch, the trial has been paused. So this is the reason for the delay, because if Trump has absolute immunity from prosecution, then he should not have to prepare for a defense. So basically, the district court judge has said, I'm pausing this. In other words, we're not even doing discovery. We're not moving forward in any part of this case until this issue is resolved, because otherwise it could impinge on his rights as a defendant. If he has a right not to be prosecuted, then we can't force him to go through the expense of doing this. We need to know. So the argument is in April. Let's assume the decision comes down in June. Then he needs 3 months, I guess, to prepare, because that's all been paused. It's been put on hold. So where are we now? July, August, September. So we're looking at September, October for a possible trial, assuming, by the way, that the Supreme Court agrees that you can't order SEAL Team 6 to assassinate your political opponent as president, which I don't think is a given. They may say he's right. I don't know. But then I think the argument will be this trial is election interference because it's, coming so close to the election. The trial should wait until after the election. Like, in other words, there's going to be a whole other debate on whether it's unseemly to make him, go through a trial right before or something. I don't think there's any legal basis to challenge that, but they will make that argument. And it may very well be that if you start a trial in September, October, there may not be a verdict until after the election. So voters may not know whether Trump engaged in a conspiracy to obstruct an official proceeding and deprive people of their civil rights.
And you can fact check me on this. A couple of things here. Number one, for those of you who are talking about making the equation between 2016 and the FBI director and this case, and they're talking about legal things, there was DOJ guidance, not laws around like cases and that kind of thing, right? There's like certain in the Department of Justice, there's things like, hey, this is the things that we like to do, try to steer away from, doing anything that may disturb an election or something like that, in terms of like 60 days out or whatever. That's not a legal basis. That's just kind of guidance that's just kind of sitting out there. And the special counsel doesn't have to go by that guidance, correct?
Right. Well, I think there's a few differences.
Okay.
As you noted, there is an internal DOJ policy that basically, prohibits or counsels prosecutors against taking overt steps in an investigation within 60 days of an election. So this means that before you or charging someone. So this means you've got an election coming up in 2 months, and all of a sudden there's a FBI raid on somebody's house, and people are like, okay, well, what happened? Because that person, hasn't been charged with anything, but you're creating it. It may look like you're ginning up some cloud of suspicion, right? Or even like charging them with a crime, like, a week before the election. My dude was charged with this crime a year and a half ago. Okay,
correct.
So, if you don't want the cloud of suspicion, you could have like just done the speedy trial. Okay, but let's leave that alone. In other words, the cloud of suspicion is there. This is not something that the Justice Department is doing right before the election. That is there. Now there's an opportunity to clear the name. So I would argue that it's actually benefits Trump to get this trial over with sooner rather than later, because he gets to, present his defense. But more importantly, Brian, this case is now under the jurisdiction of the federal judiciary.
Right.
That DOJ guidance is internal Department of Justice guidance, which is within the executive branch. That's before anything has been filed. Now it's up to Judge Chutkin. This is her case. She's not bound by the executive branch's internal policies. Everything now is in the public sphere. And so I don't think that either the rationale behind that policy or even the people to whom it's directed impacts what's going on now.
Right. Again, just to kind of reiterate something that I said earlier around why we have people like ASHA on Soulivity and to talk about all of this. We all kind of know in terms of like due process that defendants have due process rights and that kind of thing. But there's also the principle that the people, right, who the Department of Justice and the judiciary represent, we have a right to having this resolved so that in this kind of case, we have information, right? And so my hope and my wish is that this case continues. We get the information that's necessary, comes out, that this is televised and that kind of thing, and that we can use this information as part of our decision-making process before the November 3rd election season hits. And so that's just my opinion. Thank you, Asha, for that. Since we're kind of running out of time, let's just roll into this last story here. And Asha, I have to admit, I am a little hot about this one. Not a little hot. I'm a lot hot, just to be clear. This comes from CNN, where a federal judge in Texas said Tuesday that a U.S. Commerce Department agency intended to help minority-owned businesses must offer assistance to all individuals, regardless of race, agreeing with white business owners who claimed that its policies were unconstitutional. And I think one of the parts of the rationale for the judge was something around saying that these businesses are at a disadvantage is I'm paraphrasing now. It's hyperbolic, or we don't know if that's true. And so if we don't know that that's true, then they can't do that. They can't have exclusive minority business support. And so this is not even, I haven't not seen this out in major media. I mean, this story's in CNN, but I had to find it. I was just kind of reading through different things and I was like, holy crap. And I thought about, of course, this is going to get appealed. This is going to go up to probably the Supreme Court. And here again, we have a case around, just like we had with affirmative action cases, something around race and our history and how all these things were set up based upon our history and, in my opinion, current circumstances around people of who are minorities, people who have come from disadvantaged communities, and people who have historically been discriminated against. And so I just wanted to get your 2 cents on this particular case, because I was just blown away that this was even happening.
Yeah, I'm glad that you're highlighting it. To be honest, I did not know about this case, so I will be looking into it. But it doesn't surprise. So here's my initial kind of takeaways that based on what you're telling me. First, it's not surprising to me that this is a case coming out of Texas. What we see is a lot of this conservative activist litigation being filed in particular districts in Texas where there are these conservative activist judges. This is where we got the abortion case, rolling. We now have cases involving trying to prohibit government agencies from taking disinformation off of social media. So, this is kind of the experimental avenue to get these cases, like you said, to basically position them knowing they're going to be appealed because they go against the way, I mean, basically this judge is, or this, I think it's the same judge I'm thinking of, but these judges are going against the jurisprudence as it stands, which technically would be called judicial activism, knowing that it's going to get appealed, and then, I think for them, ideally getting it from the Supreme Court. And this particular issue is going to basically be an extension of what we've seen in affirmative action, that the law, so this is this idea that the law is colorblind, that the 14th Amendment is about being colorblind. And I think that it is, one legal scholar who I know has Kenji Yoshino has a great way of understanding the 14th Amendment, where he says, we've use this color blindness kind of idea, and it's the wrong way to look at the 14th Amendment. The 14th Amendment is an anti-subordination statute. Absolutely. It is there to prevent the subordination of any group relative to another. And when you interpret it that way, then it becomes okay to take corrective action to help the subordinated groups, right? Right. But what the Supreme Court has been doing is this color blindness thing. And so this is their way of, eradicating affirmative action. And I will not be surprised if this issue gets before them, that they would use that same approach. Right. And I think it just drives home that elections have consequences. When we go back to 2016, like the 3 justices that, are helping to make this happen were appointed by Trump, that give the court the majority to allow this to happen. And make no mistake, I would guess that if, Trump is elected again, he may very well have a chance to, we could end up with a whole court that is, riding this crazy train and really upending decades of how we understand, the Constitution to operate as a way to make, opportunities more fair for everyone. I mean, that is all, and reproductive rights, all these different areas. I think it's unfortunate. This is yeah.
Yeah. I thank you for that. Sincerely. I look at this case, just to let everybody know. I mean, you just brought it up, but I look at these cases that are brought in highly conservative states where their whole purpose is to get it in front of the Supreme Court, right? And have it be ruled in their favor, where these, I look as protections, right? These are protections from, as you kind of mentioned with the 14th Amendment, protections from active discrimination against minorities, right? Not, oh, well, we're trying to create a colorblind society, which in my opinion is ridiculous anyway. I think that our cultural backgrounds, our histories are all part of America. And so the issue is, do we cherish those differences and do we protect those people from other people trying to bring harm to them in whatever way it is, right? Or are we just saying, oh, well, if everything's equal, then everything's fine. And we know through history that that's just not true. We don't act that way. So we do need to have these protections in place. I think I would also say this, and this is why it kind of pisses me off. As a child of students of history and as a current student of history, those of you who may be saying, oh, well, slavery ended a long time ago. Yeah, slavery ended a long time ago. But if you know your history, there's slavery, there's post-slavery with Reconstruction, 2 or 3, depending upon what your knowledge base is and what you think about that. There's all the years of Jim Crow. There's the civil rights movement, but then even discrimination after civil rights that happened, where we're talking within a generation, people were still being discriminated against. So if you're talking about eliminating programs and agencies and programs and projects that are all designed to kind of like, hey, let's make sure that we're taking care of the people that have historically been disadvantaged, then you need to go back and read your history and know about this. I mean, most people know about. Yeah, go ahead.
I mean, you're talking about systemic racism, right?
Correct.
And what the court is really, I mean, what the court was doing in the affirmative action case was essentially denying the existence of systemic racism.
Exactly.
That recognizing that there is any disadvantage that exists in a group as an aggregate is unconstitutional, is what they were saying. Because they said, you can look at each individual person and they can talk about their experience, but in other words, you can't use race as a proxy for having certain types of hardships or experiences, is what they're saying. And I think, so basically it's essentially nullifying everything that you just described, this whole historical context.
Exactly. Which is the part, and again, we're running up on time here, which is the part that is so infuriating, because race is a construct uniquely to America, and that there have been laws and ordinances and all that based on race to discriminate. I mean, hundreds of years of it. And so now that we're in the twilight of a time period where we're maybe trying to move the ship, now you're saying that none of that existed, none of that history is there. The people and the generations that are actually living today, that actually lived in those times, don't exist, and that they all had shared experiences no matter where they lived, doesn't exist. That's the part that really, really pisses me off. And now we have another attempt to try to carve that back a little bit more. ASHA, thank you so much for being here. I could go on and on and on and on with you. But we're going to talk about your Substack real quick. The Freedom Academy with ASHA RANGAPPA. If you want to know more about what's happening in this world from a legal perspective, from a global perspective, even national security, please go and sign up today for this. ASHA, this is the bomb. I'm just going to tell you that right now.
Thank
You want to go to ASHA RANGAPPA.substack.com. I feel like I'm attending, like going to, a Holiday Inn Express after I read these, and where I feel a little smarter. Because you're talking about a whole lot. I mean, there's like detail, there's things that I didn't know about different cases and that kind of thing. And you bring a certain perspective, like, okay, well, maybe you may need to look at this way or that way. And so highly recommend it. We put it in our chats. Go sign up today and enjoy. So ASHA, thank you again for being here. Appreciate you.
Thank you
so
so much for having me.
Yeah, I can't wait till next time. I have no idea what's going to be
We can talk
next.
about the Trump trial after next time.
Right? Exactly. And to all of you, thank you for being here. This is how we do it Monday through Friday right here on Soulivity TV with Soulivity Today. Appreciate you guys being here and, motivating us to bring you conversations that empower you every single day. Again, you can listen or watch us Monday through Friday right here on Soulivity TV at 8 a.m. Eastern, or if you're out west, you can listen or watch us on KMET 1490 AM radio in Southern California. Before we get out of here, just want to remind everybody to follow us on social media, where you can learn the latest and greatest tips and learn about events that we're doing. But also, if you have a podcast provider, you can download our latest podcast by going to Spotify, Apple Podcast, or Google Podcast, whatever it is. You can go there and watch us and take us with you wherever you go. So again, thanks everybody for being here. On behalf of everybody here at soulivity.com, thanks. And we will see you next time. Bye for now.
This work is subject to copyright owned by Affinity Global LLC. Any reproduction or republication of all or part of this is expressly prohibited unless Affinity Global LLC has expressed